Hey everybody, this is Randall with PARSOL again. Thanks for your support as always. And I have an update today on the fate of the Torsilieri decision in the Pennsylvania Supreme Court. Anyone who's been following us for some time knows that this was a pretty big deal for us, and I wanted to give you the latest on what went down on May 31st. So I'm a bit late, but better late than never. First, let me say thanks again to all of you who have donated recently for our recent fundraising campaign. It's your support that allows us to keep doing what we're doing and spread the word and fight for better reentry efforts, better education efforts, and for more rational sexual offense policy here in Pennsylvania. And I also want to give a plug to a big event that we have coming up on Friday, November 15th. In Harrisburg, we have our first day-long convention. So it's going to be a conference with workshops and educational opportunities, networking opportunities, keynote from some professionals in the field. We'll be talking about prevention, we'll be talking about reform, we'll be talking about education. Great place to meet up with other like-minded folk and get more involved and just learn and connect. So again, that is Friday, November 15th here in Harrisburg. Check out our website if you're interested in attending. Get your ticket now. And if you're financially strapped, then there are support opportunities and scholarship opportunities. So let's get to it. On May 31st of this year, we finally had the decision come down from the Supreme Court of Pennsylvania, and in the matter of Torsilieri, which again, if you've been following us for some time, you're familiar with his constitutional arguments against the sex offense registry here in Pennsylvania. The decision was handed down by the Supreme Court on May 31st, and they reversed the lower court's decision. So you may remember that the lower court's decision on the Sex Offender Registration and Notification Act, SORNA, ruled that it is unconstitutional facially, that is for everybody in the state, on 7 different grounds. And that's what the lower court ruled. Well, the Supreme Court overturned that ruling, and in a 4-2 decision, they have 6 justices on the Supreme Court in Pennsylvania. In a 4-2 decision, it was ruled that the Sex Offender Registration and Notification Act, SORNA, is constitutional. And, to put it plainly, everything's fine. There's no need for any modifications. There's no need for any reform. There's no problems with SORNA constitutionally. So was a big surprise for PARSOL, for us, and really for most people watching this case after the strongly worded opinion in the lower court, for the Supreme Court to completely overturn it and really not give any kind of seriousness, if you will, to any of the arguments was a real surprise. But that's exactly what happened. 4-2 majority opinion overruled the lower court. SORNA stays intact for the state of Pennsylvania. So we did a great analysis of this on our website. I urge you to go check that out if you're interested in the gory details of this. You can find it out on our Torsilieri headquarters page at parsol.org, parsol.org. We have a nice detailed report for you, and I just want to summarize some of the key points on that. So the court decided basically on 3 grounds why SORNA can stay intact. Number 1 was a deference to legislative findings. So the court said that the legislature makes policy. They have the time to interview the experts, they have the time to collect evidence, and they don't make these decisions lightly. When they enact a law, when they pass a law, when the governor signs it, it is assumed that it is constitutional and it's tight, it's proper. And the court said that we can't, as a court, substitute our judgments for the policy decisions of the General Assembly, of the legislature. And that was, again, in a nutshell, one of their arguments, that the deference has to be given to the legislature because they put in a lot of work and effort and research into this problem or into this issue, and we can't simply overturn the will of the people of the state, which is, in theory how it works, just because we don't necessarily agree with it. Furthermore, the second argument that the court examined was the irrebuttable presumption. And some of you may remember us talking about the irrebuttable presumption. It's this idea that a law or a infringement or a statute can't be contested or disproven by evidence. So in this case, the irrebuttable presumption was that people on the registry are a high risk, period. right? That's what it says in the law, that because they're high risk, they're deserve to have some of their liberties curtailed. And it was sort of an irrebuttable presumption because there was no way for people on the list to question their status on the list. It was an irrebuttable presumption. There was no way to contest or challenge this presumption. Well, Torsilieri, the defendant in this case, he failed to establish a clear consensus of scientific evidence that proves, with a consensus, that people on the registry, PFRs, are not going to have a high rate of recidivism. And so they relied on the idea from some of the testimony that we must concede that people who have committed these types of offenses are more likely to recommit sexual offenses than people who have never committed a sexual offense. And so the court interpreted this as saying, well, the rates of recidivism are high. So again, they're looking at the subset of reoffenses that occur from people who are on the list already, PFRs. And so even though on a broad scale the rate of recidivism is very low, in single digits for PFRs, for people on the registry, the fact that there is recidivism brings up that statistic, if you will, and causes there to be a higher rate of recidivism. So the question again comes down to whether people who have a sex offense are more likely to commit another sexual offense. And again, while that rate is very low, the admission had to be made that, well, it is more likely for somebody with a sex offense to commit another sex offense. Despite the fact that it is very rare, the court kind of hung on to this position. So that was the second determination. And if you want to read more, again, check out our website, check out our analysis on this issue. Number 3, they ruled that SORNA, the Sex Offense Registry, the Sex Offender Registration and Notification Act, is non-punitive. They ruled that the registry is non-punitive. So they argued that the requirements of SORNA are public safety measures. They're intended to protect the public. That was their determination on why this law was passed. It wasn't meant to punish people, it was meant to protect the public. That was the legislative intent. That's why this law was passed. Furthermore, the legislature did put in some safeguards to make sure that the registration requirements weren't overly onerous. After the last time we had some constitutional issues with this in 2018, there were some safeguards and concessions made with SORNA to make it less onerous, namely the 25-year relief mechanism. That is, after 25 years you can petition to be off the registry. You're not going to be on it for life necessarily. And there is a more streamlined process for updating your registration information. If you meet certain time criterias and behavior criterias, then you can, phone in your information, which doesn't make you have to go in person as much. And so those were some of the concessions that the court pointed out that did reduce the punishment and the onerousness of having to register regularly. So again, SORNA is not excessive. It is, as a public safety measure, what it does in order to inform the public. These steps that must be taken for PFRs are not excessive. And the aim is to prevent sexual offenses by notifying the public and enabling them to take action. The court pointed out that that was the intent of the legislature, and that is the reason that SORNA exists, to inform the public and to allow them to take action and have precautions to keep themselves and their loved ones safe. So those are the arguments made that had this majority ruling, and importantly, when we think about where do we go from here, what's next? Well, Torsilieri's lawyers have not indicated that they intend to appeal to federal courts and to the Supreme Court of the United States. They don't intend to do that. So as far as Torsilieri goes, it's case closed. This is the end of the Torsilieri line. That doesn't mean that there won't be future litigation, that there won't be future cases and challenges to SORNA in Pennsylvania. There almost certainly will be. However, it's a much higher bar now. It's a much higher bar to pass. And why is that? It's because the Supreme Court decided with a lot of effort and care put in this decision, that SORNA is not punitive. So if you have a civil regulatory scheme, a public safety measure that has been deemed to be not punitive, now we can't talk about ex post facto because we're not imposing punishments anymore. We can't talk about cruel and unusual punishment because it's not a punishment. And so, however the next court challenge comes to this, is going to have to prove somehow, well, that it is punishment and that the Supreme Court somehow got it wrong, or that they didn't consider these elements. And that's for another day and for another litigant to challenge the court with. So where do we go now? Again, we have kind of lost this ace up our sleeve as far as any kind of leverage we might have had for policymakers and for outreach to policymakers. But the work continues, right? There is still a lot of room for improvement in this area, and we still have a lot of issues that we need to tackle as PARSOL, and we need your support and help for. I think the chief among them is a meaningful review process, whereas we can have a law passed to have a meaningful review process for getting people off of the registry. It is a one-size-fits-all scheme in where if you've been convicted of a certain offense, then you go on the list for 15 years, 25 years, or lifetime, depending on your tier, right? And that doesn't consider things like the age of the person. Maybe they had an intellectual or a developmental disability. Maybe they were on the autism spectrum when they committed their crime. And doesn't that need to be factored into the decision? Perhaps somebody is of an elderly age now, or they have a chronic illness. They're in their 80s now, yet they're still subject to SORNA's requirements. So even though we have a review process in Pennsylvania at the 25-year mark, that's a long time to wait for some people. If we're talking about somebody who's 18 or 19 years old on the autism spectrum who made a mistake on the internet, they're going to have to wait until they're 34, ish, to get the chance to be taken off of the list. And right now there's no other way to do it. You're not getting off. And so what we are pushing for as PARSOL is a meaningful review process to take into account the circumstances of somebody's life, where they were at, what kind of punishments they received and how they handled them, and where they're at now, so that we can give people a chance to move on with their lives and be done with what we know as to be indeed onerous and punitive and public shaming and ostracizing requirements of being on a sex offense registry for the rest of your life, or 25 years if you are able to access that relief mechanism. So that's one direction that we want to take, to contact our policymakers and see about how we can implement a meaningful review process after a certain amount of years. Maybe that's 2 years, maybe that's 5 years, maybe that's 10 years. Because again, if what we're trying to do is inform the public and give people the opportunity to make decisions as the court decided that is what SORNA's aim is, don't we want to identify the people who are high risk and focus attention on those if they exist? And don't we want to give those people who have demonstrated change and who can demonstrate that they're not a high risk to move on with their lives and carry on and be a productive citizen and have every chance at re-entry that anyone else does, and every chance at life, liberty, and the pursuit of happiness that everyone else does? So that's all I got for you today, y'all. Thanks for checking out another one of our videos. Go to our website, check out the analysis again. If you haven't subscribed to the YouTube channel yet, please do subscribe. It helps us out. Share this video with a friend who might have been impacted by these issues, and check out our social media as always. So again, our conference is coming up on Friday, November 15th. Get your tickets now, and I hope to see you in Harrisburg.